Good morning. Good morning, everybody. And for the global religion, Islam, celebrating uh, Ramjan. Congratulations, Eid Mubarak. It's all right. For young lawyers, those who are watching criminal proceedings by crowd before 46 court at present where court proceedings are dealt and some within that third floor premises wherever the court proceedings are entertained. And you would have astonishingly watching a person's from dominated community and the graduates from uh, excel law colleges are arguing quash proceedings in respect of drugs and cosmetic cases. It is not that much of hard to argue like that because they are concentrating on exclusive field, therefore they are able to argue the case. That apart, there may be a backing of officials who are working in that field or who would have retired may guide them what to do, what not to do. But those who are aspiring to be reaching any field and want to be a judge, particularly assistant public prosecutors, and district municipal district judges examination must follow the judgment. It's a very fantastic judgment. By reading the judgment you can understand how drugs and cosmetic cases are being being filed by following what all are the procedures. And also multi number of judgments were discussed as to by filing a complaint, because 190 CRPC permits you to file a complaint for taking cognizance of offence. 190 A says complaint by private persons. Complaint B, complaint by the public servant. Complaint C by final report. The B, 19B says public servant. So under these provisions only complaints are being filed by the drugs inspector, corporation authorities, regular protection forces, and NCB, NIA, because earlier, whatever it may be, the multi number of judgments have been discussed in this so as to understand under what all are the complaint by public servant may be initiated under this and issuing process 202. So this is judgment AR 2025 Supreme Court 814. AR 2025 Supreme Court 814. Inox Air Products Limited and versus State of Andhra Pradesh. They have dealt provisions of 482 CRPC, 202 CRPC and 18A5 of Drugs and Cosmetics Act. You can very well ascertain the facts and the procedure how cases were filed after issuing notice to companies for production of documents, so many things. This had happened in Andhra Pradesh because original company was at Navi Mumbai, Madras. So you can very well read this section paragraph 3 completely, wherein 3.6 they have filed a complaint under section 18A 5 of the Drugs and Cosmetics Act and 65 1B of Drugs and Cosmetic Rules 1945. Act was 1940. The problem was that the allegation was that they do not have a form, they have form, but they do not have the another form to sell at Andhra Pradesh. So the Supreme Court, though the Honorable High Court has rejected the grounds for quashing the petition, the Supreme Court has categorically held Form 20B was violation, they say. then that those things were available at paragraph 60. And the manufacture was also extensively defined. That was available at paragraph 26. The form 25 and 20b was discussed at paragraph 22, make you to understand what is manufacture, and manufacture has been extensively discussed. Then also they say the word subject to was also elaborately discussed in paragraph 29. What was the exact meaning of subject to? Subject to means liable, subordinate, subservient, inferior, obedient to, governed or affected. So this was also deeply discussed. So it is far better the persons can very well read and understand it by page. Read once, twice, thrice, and to make yourself understand, because this case will help you to file quash proceedings not only on Drugs and Cosmetics Act, in the other cases also. Then they are dealt with the Pepsi Food case and multi-number of cases, including Sunil Batra, Ashok Mal Bapna latest case held that it is not formality of land magistrate to take complaint on file and issue process if filed by the public servant. So they themselves say sufficient ground for proceedings is that was since available under section 204. The magistrate must definitely apply his mind to find out the truthfulness of the allegation otherwise, and prima facie committed by any of the accused or all the accused. So he cannot be a silent spectator at the time of regarding preliminary evidence before summoning the accused. So this is what they have held, categorically held, multi-number of cases. I may not be reading the entire things, this may because it may be boring young lawyers, but young lawyers must go through the judgment deeply, once, twice, thrice, to understand the procedure for drugs and cosmetic cases. And if you are becoming at home, then you can very well opt for standing counsels or a contract permanent counsel for any drug companies. So many things are there. Equip yourself with you, like Usain Bolt and so many young women cricketers are from villages competing with Australians and what we say New Zealand, England players, and particularly including West Indies players. Like that, you should also cope up with this standard of knowledge, how this judgment is discussed about various manufacture was deeply defined. That paragraph 23, the subject to was defined under section 29, and then the question arises application of mind. So before issuance of sufficient ground. All these have been categorically discussed very well in this judgment. So the Drugs and Cosmetics Act deals with special provisions apart from NDPS Act. NDPS Act also narcotic drugs and psychotropic substances. This is Drugs and Cosmetics Act. They have entered into hospital authorities is the drugs and the drugs which was manufactured by Bombay company and which was sold by Andhra Pradesh, name was different. So many things are there. For all that, the Supreme Court has categorically answered. So it is far better that you understand the scope of Drugs and Cosmetics Act, which was not revisited for so many years, and except Jan Suraksha Act, wherein several offences were decriminalized. I hope this drugs and cosmetics, some of the provisions also decriminalized. What is meant by decriminalization? Means instead of sentencing him fine amount and compounding the offences. That is called decriminalization. Best wishes.